Patrick. Thank you.
All set.
Thank you. Welcome to the January 27th, 2021 meeting of the Albany County Legislature's Law Committee. Welcome, everybody. Hope you're doing well. I'd like to start if Ms. Kennedy could please take the roll.
Ms. Platsky?
Yes. Present.
Ms. Cunningham?
Here.
Bergdorf?
Here.
Beanie?
Here.
Coon?
Here.
Mayo?
Here.
Peter?
Here.
Ricard?
Present.
And Whalen?
Here.
All present, Madam Chairwoman.
Thank you so much. Have you had a chance to look over the previous minutes?
Motion to move them.
Second.
Thank you, Ms. Cunningham. Thank you, Mr. Peter, for the second. All in favor?
Aye.
Aye.
Passes unanimously. Thank you. To start us off, I'd actually like to take a few items out of order. I thought for Ms. Ziegler's sake, unless she enjoys spending her Wednesday evenings with us, we could take items 5, 6, and 7 first this evening.
Thank you very much. I appreciate that.
Okay. Let's go right to item 5, which is right when my screen turned off. There we go. Okay, it's for the submission of a grant application to the New York State Office of Victim Services regarding the Victim and Witness Assistance Grant Program. So Ms. Ziegler, would you like to say a few words about this?
Yes, please. This is a continuation of a grant that we've had. This grant allows us to provide direct services to our victims. It funds staff and some other lines. We're very successful. This also allows us to do a lot of work in schools. So it's been an interesting year, but we found that we've been able to work remotely very successfully.
Great, thank you. Any questions for Ms. Ziegler?
Madam Chairman.
Yes, Mr. Ricker.
Chair first. Excuse me.
Just chair is fine.
Yeah. Madam Chair. Karen, I see this is 100% funded by the federal government.
Yes, it is.
So there's no concern there that there's a possibility of not getting the grant money.
No, in fact, they waited. This grant starts in October, and we were awarded it very recently, so they feel secure in the funding.
Thank you very much.
Yes.
I'll support it with great enthusiasm.
Thank
Madam
you.
Chair,
Yes, Mr. Peter.
if there are no further questions, I'd like to make a motion to move this.
Any further questions?
Second.
Thank you, Mr. Ricard. All in favor?
Aye.
Aye.
Thank you. Item 6, Ms. Ziegler, authorizing an agreement with the New York State Division of Criminal Justice Services regarding rape crisis services and prevention programming.
Yes, this is we had this grant. This was a brand new grant cycle. Again, they waited until to ensure that the funding was secure. It's slightly smaller than the grant we just finished, but that was their attempt. Their part of their reasoning was again to secure the funding. So this is a continuation of a grant that we've had, although it begins a brand new 5-year grant cycle.
Very good. Thank you. Any questions for Ms. Ziegler? No? May I have a motion?
Motion, Madam Chair.
Thank you, Mr. Peter. Seconded by Mr. Bergdorf. Thank you. All in favor?
Aye. Aye.
Any opposed? No. Motion passes unanimously. Thank you so much. Item 7, authorize an agreement with New York State Division of Criminal Justice Services and an interdepartmental agreement regarding the Stop Violence Against Women Act grant. Ms. Ziegler.
Thank you. This is a grant that we had. It allows us to do amazing work with women with sexual violence, domestic violence, dating violence, and stalking. We primarily use this grant. It funds our caseworkers in courts. Albany City Court and Colony Courts are the 2 grants we really direct this to because those are the 2 highest rates of DV in the county. So it primarily funds those. It also helps us do some Prison Rape Elimination Act work at the jail, as well as the county sexual assault resource team. So it's current funding and just a continuation.
Okay. Any questions for Ms. Ziegler? May I have a motion?
Motion, Madam Chair.
Sure,
Second.
Mr. Peter, second by Mr. Bergdorf. All in favor?
Aye.
Any opposed? Thank you. Motion passes unanimously. Thank you, Ms. Ziegler. Appreciate you being with us tonight.
Thank you so much. Appreciate everything. Have a great night.
Thank you. You too.
Bye-bye.
While we're here, let's go on to item 8. This was for approving the bylaws of the Advanced Albany County Alliance Local Development Corporation. And I believe Mr. Lucas, Lucas Rogers wanted to say something on this.
Yeah, thank you, Madam Chair. We actually are going to request that this item be tabled this month for consideration next month as we seek to tie up a couple loose ends and make sure what we're acting on is all parties are on the same page.
Okay. Thank you so much.
Thank you.
Thanks for being here.
Thanks for having me.
All right. Tabled at request of sponsor. All right. With that done, let's go
I'm
back.
sorry, Madam Chair. That
Yeah.
requires a motion to table
Oh,
that.
I'm sorry. All right. May I have a
Madam-
motion to table?
I'll
Mr.
second.
Peter, you're taking all the fun.
All right.
I'm sorry. Let's spread the wealth.
Yeah,
I'll
let's
make the
someone else
motion.
have a turn.
I'll make the motion.
All right, Mr. Ricard's making the motion. How about a second by Ms. Cunningham?
Second.
All right, thank you.
Aye.
All in favor?
Aye.
Thank you. Any opposed? Nope. Thank you. We're tabling number 8. Passes unanimously. Thank you, Mr. Rogers.
Thank you.
Okay. Now let's go back to item 2, local law I. This is a public hearing on proposed local law I to prohibit smoking in common areas of multiple unit dwellings.
Motion. Well, it's just the public hearing, right?
It is the public hearing. I just wanted to
Aye.
give Mr. Efikoro an
I'm
opportunity to
sorry.
say a
I'm
few
sorry.
words. I think there had been some changes to definitions and what. I just didn't want to know if you wanted to bring those to the attention of the group. So, Mr. Efikoro, if you care.
Oh, yes. So can you all hear me?
Yes, thank you.
Okay, awesome. So we did a few modifications to the local law from basically suggestions from fellow members. And basically to address the issue of when one family unit is very close to a multi-unit building. So we addressed that issue. And also, as you can see, if you've already read the language, there would be no police enforcement of this local law, of this legislation. And so it's basically encouraging landlords to cooperate, and also that landlords can also be fined if they do not cooperate. So how would that happen is for tenants to report issues whereby people are not enforcing this legislation, or if they have issues with smoking in their units, in their buildings, they can bring it to the attention of the health department for enforcement. And if you have any question, just let me know, and we can go from there, and just building up from what we stated previously.
Okay.
Madam Chair.
Yes, Mr. Bergdorf.
Yes, Ferraro. I see that you did make, some changes. And do the changes protect people that live in town? This may be also a question for Rebecca. Does these changes, the way I read them, only apply to areas where other people are allowed to enter? So that if you have a townhouse condo situation where you have a deck that is yours, you could still have a cigar on your deck. Am I reading this accurately?
Correct. So if it's a deck and is not somewhere that is utilized by other members in a unit, then it's your own property. If if assuming it is a one-family house and not a two-family house, whereby not a multi-dwelling unit whereby other people can use that deck, or is 5 feet away from it, another deck or something like that.
Okay. The only other concern I had, which I'm not sure was addressed, was, some of the apartment complexes in Colony are, 20, 30, 40 acres. And you could be 100 yards away from any building and on a cut grass and having a picnic. And this seems to say that an outdoor common area was anything and grassy or landscaped areas. Does that include general lawn? Does that make the entire property non-smoking?
If it is a space where other people utilize, then there should be no smoking in that space. Correct.
If I may, Mr. Ficoro, jump in.
Yes.
Okay. This would prohibit only for rental multiple unit dwellings, smoking and vaping in indoor common areas. Outdoor common areas are excluded except within 5 feet of an outdoor ventilation intake. So that has been changed substantially from the last version you saw, which was, I believe, 50 feet. And outdoor common areas were included. We've now excluded outdoor common areas from that ban so that it only applies to the smoking prohibition is only applying to the indoor common areas.
Well,
So you could still smoke at a pool or something. Okay.
where does
Can I ask,
that-
can I ask a question?
Could you take me through the verbiage, Rebecca, on that?
The prohibition itself is found in section 5, and it says that smoking and vaping are prohibited in indoor common areas of multiple unit dwellings. And
Wait a second.
oh, sorry.
In indoor common areas, okay.
And within 5 feet of any outdoor ventilation intake, including but not limited to ventilation intakes that are located on attached balconies or patios. So if there is a ventilation intake and that's on an outdoor patio or a balcony, it would be included in the ban, but only where there is an intake. So if you have a patio or a balcony that does not have an intake near there, it's just to prevent smoke or vapor from being instituted into an adjacent unit, I guess, that is not the one that has the smoking added, so that it's not introducing it into a new environment.
So in essence, everything under outdoor common areas, you could smoke if you were not within 5 foot of an intake.
So at this point, we almost don't really need to define outdoor common areas because those really, okay.
It was
Yeah,
defined
that was-
more to include it.
Well, there's a whole new section that's underlined in the bill that does define outdoor common areas. So if that's the case, I think you've done an admirable job in protecting people's rights in their homes and protecting them against secondhand smoke, but yet, having some common sense that people can smoke in an area where they would not affect anyone else.
Madam Chair.
Okay. Mr. Ricard, sure.
Thank you, Madam Chair. Just a couple of follow-up questions. In our cities, we have a lot of, Marara, you know this. Your friend lives right next down to my rental property on the island there. The houses are really close down there. They're literally within 3 feet of each other, between one house and another. So my question is, and I understand what you said, Rebecca, as an example, on a front porch, if somebody's 5 feet away from a window, could that individual smoke? Or let's say 6 feet away from that window, could that individual smoke on the front porch?
If it is 6 feet, then it's more than the 5 feet. If it is 5 feet, then you shouldn't be smoking.
Right.
And if it is 6 feet and you know that it's really affecting somebody, then you really shouldn't be smoking there. But according to the law, if you want to be technical about it, you can smoke, but it's not ideal for you to smoke when you know it's affecting other people.
Okay. So getting back to like a deck on the back, an individual could smoke on a deck on the back of a property if all the tenants in a particular building use that deck?
No.
As long as there is no outdoor ventilation intake
Right.
there, then it would be permissible.
Right. So if there's no outdoor ventilation intake, obviously you're taking air from the outside, putting it inside, they could smoke there.
If it's an enclosed deck, it depends on if it's an enclosed deck, then no. It's
Open end. Well, the deck would, let's say the deck would have a roof over it, but it's still exposed to the air. You know, just a cover on it, but no, the sides are exposed to the air.
I mean, according to the language in the legislation, you can smoke, but left to me, I would say no. But with the language of the legislation, you can smoke. Yes.
Okay.
I have a question, Madam Chairwoman.
Sure, Ms. Whalen.
I have a real problem with imposing the penalty on the landlord, property owner, property manager having control. It says, wait, where is the language? Any property owner, property manager, and or Section 6 or other person having control of a multiple unit dwelling who violate this local law shall be subject to a fine. I mean, you could have tenants that if you're not on site all the time and they're smoking in these areas and you can't evict them because of COVID, what are you going to get, a $500 fine every time? Why is there no imposition of a fine on the perpetrator, the tenant? So like, I'm a landlord, I could post signs till my heart's content and send notices to them. And if they still choose to violate the law and I can't even evict them because of COVID, what am I supposed to do? Get fined $500 every time and not even call the police? Like, why would I be violating a provision if I'm not smoking or vaping? If I put up the signs and I've written the notices to the tenants, like, you know, and I put it in their leases and updated their leases that they can't smoke or vape in common areas, why am I going to be fined $500 for each violation? That sounds very, that's like.
Okay, we hear you, we hear you.
Yeah.
Who would like to address that? Mr. Epicoro or
Yes.
Ms. Kennedy?
That is the discretion of the judge. I think if you go in front of a judge and the judge tells you, and you tell the judge that you could not evict someone or you could not enforce it due to the pandemic, you could not evict anybody, I don't think a judge would fine you $500 for not being able to do that. I think some rules and regulations are being on pause right now, and pretty much it's the discretion of the judge to do to that effect. Now,
who will be bringing the landlord in front of the judge and who will be fining them $500? Is that in here?
Now the Department of Health can fine the landlord that $500 fee, but you have a right to appeal that.
Wait a second, hold on. Excuse me, I'm in a meeting. I mean, it's very expensive for a landlord. If you have tenants that are just, you know, the perpetrator has no liability in this. That's not fair. I mean, you could have a tenant that you could have a tenant that you can't get rid of at all and who could be smoking all day long and they're not taking any accountability here.
Well, that would be during the COVID issues.
Or even outside of COVID. What if they just want to go violate the law with no responsibility on them? They could do it all day long and think it's really funny to have the landlord getting, like, you know, banged with fines every 5 seconds from the Department of Health, $500. I mean,
when that happens, you can
other tenants.
Understood. Let Mr. Ficoro respond, please.
Now, when that happens, you can bring your paperwork and everything to a judge and let them know, or to the Department of Health, and let them know that you have been trying to evict this tenant that is in constant violation, and I'm sure they will use their discretion to.
No, you can't be sure of that at all. You cannot be sure of what a judge is going to do. Why would you have a landlord who has to get a lawyer and then go fight this when a tenant is the one that is actually the one that's the perpetrator? If someone is smoking in violation of the law and it's not the landlord or the property manager, you should also at least have some kind of punitive fine on the person that's actually doing the misdeed and putting the other folks in the building at risk. Why are they not going?
Okay, I think this is
Okay,
open for
sorry.
discussion.
Okay.
Let's have some other people chime in on this. Mr. Kuhn and then Ms. Cunningham, please.
Sure. I think that Ms. Whalen is actually making some points here that may weigh towards a few modifications of this. The prohibition in Section 5 is on smoking and vaping in these particular areas, right? That's the basic teeth of this thing. You can't smoke or vape in these places. And then Section 6, well, let's skip Section 6 for a second. Go into Section 7. Section 7 has enforcement and administration, and it is there that the obligations of the property owners or the property managers are set forth, right? So you have the smoker is violating Section 5 by smoking and vaping, and the property owner is violating Section 7 if they don't, post this information, right? So then Section 6 says any property owner, property manager, or other person having control of the dwelling who violates any provision of this local law shall be subject to the imposition of a civil penalty. Well, don't we really mean that any property owner who violates any provision of Section 7? Because that is the section that is relevant to the property owners. So I feel like that to the extent that we are penalizing property owners, it should be for violations of Section 7. And then to Ms. Whalen's point, is there any prohibition? Well, does the prohibition in here on smoking and vaping have any teeth with respect to the smoker or vapor in question? It doesn't seem to. It seems like the only penalties in this are to the property owner, and the conduct in question is going to be, in many cases, outside the property owner's control. So I do have some other questions about some of the language here, but I'd like to stop there and get some.
So with that, the purpose of that provision is to see that the landlords enforce this. And so how they enforce this is by pursuing eviction when they have a tenant that is violating the provisions of this law. Now, where the $500 fine comes in is when the landlord is not doing anything to enforce these provisions of this law. That is where that $500 fine comes in.
So for instance, if a landlord didn't post signs, didn't have it in the lease, and perhaps after multiple requests or something from other tenants, took no action against another tenant.
Correct.
Okay, and then a penalty, I will get to you, Ms. Cunningham, just in a second. The penalty on the individual would be being able to be evicted for smoking. Okay, just to clarify.
Well, should we say that? I mean, should we say that a violation of this provision shall be just cause for an eviction in Albany County? Do we need to, are we saying that's kind of just implied? And I don't know about just sort of saying things are implied. I mean, should we say that expressly?
I believe that's the second sentence of Section 7.
Yes.
It applies to evictions to the extent allowable by state and local law.
Oh, it says may pursue evictions for violations of this law.
So should it be may or shall?
It's up to the landlord to pursue eviction.
No,
But are we
excuse me, I just
obligating
have to, Madam Chairwoman, it's very expensive for landlords to pursue evictions. I used to represent people and landlords.
Yeah.
19,000 once it cost a landlord to pursue an eviction. It's not that easy to evict people or
Okay.
you have fines, you have to get RJI numbers and index numbers. I mean, I agree that you should post, you should make posts everywhere on the property you should definitely write a letter, serve it on them, tell them to stop smoking. But to actually impose upon the landlord an obligation to start an eviction, especially in the course of this pandemic when they can't even evict anybody for
I
anything.
think it's clear, Ms. Whalen, that you can't evict during the pandemic. We have a couple people with their hands up right now that I need to get to.
Oh, sorry,
All
I'm
right,
sorry.
that's okay. I know you're excited about it. We want to try to get to everybody.
Well,
too.
I feel like my
Ms.
last comments
Cunningham?
Yeah, I guess my feeling, well, first, I'd like to be added as a co-sponsor. Second, I think my assumption is if you're a landlord, you write a lease that this provision would be no different than violations of many other local laws that you would want to discourage of your tenants. You know, you don't want them violating this local law that makes it uncomfortable for other tenants, but that's not unlike many other things you certainly don't want your tenants doing. So I'm not really understanding why you wouldn't just, if this local law passed, you would amend your lease if you had to. I assume you have provisions in your leases that that allow you remedy if you have tenants that are violating local laws. So I guess I don't understand why this would be any different than any other violations that you want to discourage, or you certainly don't want to have tenants that are violating local laws.
Mhm.
Madam Chair.
Yeah, Mr. Peter.
Just two quick things. One, this is a similar situation as we have in the city of Albany and other places where, for example, tenants will leave out their trash on the wrong nights and there's a fine that comes to that. What landlords typically have done is put in their lease that if you violate that, that fee will be added on to you, and there's ample proof and ease of use of that. My only two potential, follow-ups to this is we might either want to consider a graduated or a slightly lower fine, because $500 to be passed on to the tenant, for example. So, for example, on a first thing, if someone got a $500 fine, they instantly passed on to the tenant. That's a lot of money for some individuals, and it seems like maybe $100 with the second fine being $250 and third thereafter, or something of that, might be appropriate. In addition, we might want to timed in on this that landlords are responsible for this after the passage of this to be included in their leases, rather than, because you can't change a lease in the middle of a term, and so we want to give people at least the opportunity for that. So again, I don't think it, the answer isn't it's eviction or this. I think it's that, we have to know, and landlords do this all the time, that if there's a fee based on a behavior of a certain individual, that fee can be passed on, and it can be.
So,
Mark,
to
I don't think you're muted.
address your last point on section 7, it actually says that that all persons having control of multiple unit dwellings shall include in their lease agreement dated after the effective date of this law. So any lease that is dated after the effective date of this law would have that agreement. So you don't necessarily have to go amend a lease.
What I'm saying is that they're like, but if there's going to be a fine levied for someone not being able to do it, like it can be included in the lease, but there has to be some grace period in this. So if it's requiring that new leases do it, but there's not an enforcement grace period until those new leases, you have a period where you're enforcing, but the person can't put it in their lease. So that's my point to it. But anyway,
I don't think we can enforce
right
until that lease is renewed.
Right.
Would be my interpretation of this. I think it's also not that clear what a landlord, I support this, I'm just trying to see how this is going to work. Not that clear what a landlord does that would trigger the penalty.
Can I
Madam
ask a
Chair,
follow-up question on that too, Madam Chair?
Sure, Mr. Ricard, then Ms. Whalen.
Thank you, Madam Chair. Just a couple of follow-up questions on that. So, and I'm going to ask the attorneys on this call about this too. So if somebody had a 3-year lease, you can't go back and redo that 3-year lease. It wouldn't be applicable to that lease expires. Is that correct?
As written, this law would only apply to lease agreements dated after the date of the effective date of this law.
Okay, so my second question is, what if a tenant has a month to month? I know of plenty of landlords who have tenants that only do month to month. They refuse to do a lease. How would that apply in that case?
I
mean,
do. That's
Month
correct.
to month,
Bill.
no lease. They
A
just have a
they have
rental
verbal.
agreement. They don't have a lease per se. There's a difference between a lease and a rental agreement. So some tenants, they will not sign a lease. They only want to do a rental agreement, which is a month to month agreement. So how would this law apply to that in a rental agreement of a month to month?
I would assume if you don't have a lease, then your rent is pretty much your lease agreement for the apartment that you are living in or for the space you're renting. So if you're doing month to month, then it applies at the end of that next month, I would assume.
Okay,
Certainly
I think
also
we've
said-
started
get-
some,
wait, Madam
just a
Chair.
moment, I'll get to you.
Okay.
Hold on, I didn't forget about you. I think we're raising some good issues. This is just for the public hearing at this time. I think there's some things that unfortunately might want to get a little more consideration, but so it's we're the more we work with this now, the better the legislation will be when it's complete. So Ms. Whalen, some closing thoughts from you, and then we need to
I'm-
have a motion to amend the date for the public hearing, and then a vote on the public hearing itself. So Ms. Whalen.
I am all for the health and safety of the individuals living in the buildings, but I definitely think that you have to make it clear in this legislation that the perpetrators that are violating this, the ones that are actually smoking and vaping and putting the others at risk, have to take the same amount of accountability as the landlord in enforcing this. And then my other concern is this, because to Miss Cunningham's point, yes, you have a lease. Some people don't have leases. We just have verbal, month-to-month agreements. And then you just have policies that are set forth that they have to sign. But if someone violates a term of the lease, say it's a no pet, you can't have a pet. So you tell them, get rid of your pet or I'm going to evict you. You can evict them, but it can take months and months and months. So I guess my question is, and it's very costly to evict people when they won't leave. But the question I have is, what if during the entire eviction process, which sometimes can go on for an entire year or even more, they're still smoking and vaping? Are you going to be accruing fines, $500 every time someone else reports them? The Department of Health, will an eviction matter stay? Any further fines upon you as you're trying to get them out? I mean, evictions can live a long, long life of their own.
I mean, this law is basically, it's just the same way it's enforced. It would be enforced the same way every other law is enforced. So as long as the landlord is pursuing the eviction and doing what they are supposed to be doing, there shouldn't be any fine that is coming to or the landlord shouldn't be paying any fine as long as they are complying. So if you can show that you've actually been pursuing eviction for this tenant who's refused to pass, then it's really not on you to pay that fine.
Madam Chair.
Okay, we've got, I do want to wrap this up. Mr. Bergdorf has his hand raised.
Just a quick question on vaping. Does the definition of vaping include vaping anything or just cigarettes? For example, if marijuana becomes legal in 2021, can you vape marijuana in an outdoor common area? Or is it essentially like having a beer? I don't know, but I'm not quite sure. I would just like people to think about the definition of vaping and what the potential impact of vaping marijuana might be in close quarters. It could be more objectionable than cigarette smoke.
So
Mr. Kuhn?
vaping, smoking, whether just because you're smoking marijuana doesn't make it the best thing. It doesn't make it like the good thing to smoke or the good like health hazard perhaps. So if you're smoking marijuana in a place where it says there should be no smoking or where it is not responsible to smoke in, then it's not legal for you to smoke in that space also, whether it's marijuana, cigarette, or anything else that you're smoking.
I would agree with you, but then you should take a look at your definition of vaping, because your definition seems to be pretty restrictive to cigarette or tobacco-oriented items.
Mr. Kuhn?
Yeah,
Very
I'll try to do this
briefly.
rapidly. I mean, listen, we might have to spend more than 15 minutes on this before we pass it, but I would suggest section 7, there should be something in there perhaps we should consider that if some landlord complies with all the provisions of section 7, then that's a safe harbor and that they're not exposed to then the penalties. I mean, it seems to me if the landlord does everything you ask them to do under section 7 and some scofflaw tenant is still smoking and vaping, well, I mean, what else do you want the landlord to do? They've done what they're supposed to do. They put it in their lease. They've got the signs posted saying you're not supposed to do this. And then to still fine them if somebody is, just ignoring that, I don't know. It seems like that's not really their fault if that happens. I don't understand why outdoor common area is even in this legislation. It's a defined term, but then it isn't used anywhere else in the legislation.
It isn't used, yeah.
And then question, indoor common area. Every interior enclosed or unenclosed area. What does that mean? What does that mean? Enclosed or unenclosed? What's an unenclosed interior area?
Courtyard, I think.
Yes, it does include an interior courtyard, which may or may not be enclosed depending on the situation.
Yeah, it might be where people do their barbecuing, for a group of units or something.
Oh, okay. So an outdoor, but that would be outdoors, wouldn't it?
But for this purpose, it would be that would not be a place where you should impose your secondhand smoke on other people.
Well, understood, but I don't disagree with that. But it's certainly if that's what you're saying, it's gonna be confusing when people are like, "Well, I'm outdoors. This doesn't apply. I'm out." So I guess I'll end there. But that is not clear.
So I think maybe a little more crafting would be beneficial. Mr. Peter.
On that note, I just have a question of the sponsor. Would the sponsor like to continue with this for public hearing and move it now? Or would it like to table it, get a list of the questions and concerns of the committee and bring it back next month? I support this. I support what you're doing. I want to make sure it gets right. And I just want to ask what you want to do, based on the conversation that we're having.
I also support this.
I also support this. I support this 1,000%. I just want to make it, I just want it to be as clean and as enforceable as possible.
Exactly.
I support it too. And it's important we take care of the safe and the healthy of all of our tenants. And
Understood.
I like to see some changes to it.
Right.
Like Jeff just alluded to. I really like what Jeff just said.
Guys, I was asking the sponsor.
We got to put in our 2 cents too.
Okay, Mr. Ficoro, if you have a moment.
Please, Mr.
Yes,
Ficoro.
I did actually agree to what you said, and especially what Jeff, what you said, the last point you made. I agree with that. We should add that to it right away, and also to include all of the clarity that it needs, because it's going to be a legislation. It's going to be a law, so the judges need to be able to interpret it correctly also. So I'm not sure, Rebecca, if we can make those changes before the public hearing date, or if you think we should table it for now.
In your discretion, Mr. Ficoro, we could make some changes before the public hearing, but you may wish to, given the comments tonight, you may wish to table it another month for the
Well,
purpose of.
these are all pretty non-substantive cleanup issues, right? I mean, I don't think any of this is my perspective, and Mr. Ficora, it's your legislation, but I think it can probably go to hearing and then, clean up this stuff afterward, but I don't exactly know what the standard is there.
So would the intent of that be to get even more input before we do one more draft here? And Ms. Cunningham, you're next, as I'm trying to stop this meeting. We don't usually have this much discussion on a public hearing.
Yeah, so we can table it, and pretty much I think when we table it, we can send it to the members to see if it addressed the issues that they raised, and before we have the next meeting.
Okay,
If that works.
sure, Ms. Cunningham. I can't hear you. I'm sorry. You're still.
So sorry. So I would just want to caution us that we don't sort of neuter this too much, and going to the point I think Jeff made. So let's paint a picture. You have a tenant, and the tenant, despite signage, despite language in the lease that precludes them from violating the law, and is strongly worded language, they persist and they continuously violate this and smoke in some areas near a vent or something, and everybody else in the building is suffering. So the recourse, yes, is on the landlord, because the landlord in the end is the only person that can remedy the situation if you have somebody that will not comply. And I'm sorry that it's an onerous process. Eviction sounds like a terribly onerous process that takes a lot of time, but ultimately, I think it is the landlord's responsibility ultimately to make sure that this tenant doesn't persist with this behavior. So without some sort of responsibility that does rest ultimately on the landlord, you may have neutered it too much. So the landlord just throws up their hands and says, well, I'm sorry, I put the signs up and they just won't do it. I've warned them. But without some sort of direct penalty that impacts them, it's easier for them to say,
what about the smoker? What about the perpetrator that's doing it? What about the jerk that's smoking and
let's
doing it? The
draw
tenant.
this to a close. Mr.
Tenant
Efracoro,
should
are
be
you,
fine too.
excuse me, Mr. Efracoro, I'm sure you've been taking notes on the comments from everybody. Are you requesting to table this at this time?
Yes.
Okay, Ms. Kennedy, we don't need a vote on that, do we? No, okay. Thank you. Item 1 is tabled at the request of sponsor. Maybe you can send Efracoro your ideas, Mr. Efracoro, your ideas. And
That would be great.
To help him tighten up this statute, give it some strength, a little more structure, and address people's concerns. Let us move on to, item 2 obviously is tabled at request of sponsor. That's the bill itself. Let's go on to item 3, which is, item 4, which is local law J, delivery fees. Let me get the correct title here. Local law J, limiting third-party food delivery services during a declared emergency. I don't think we're limiting the services, we're limiting the fees on the services, but in any event.
Right, can we change that? Shouldn't it be third-party food delivery service fees? I mean, we can do that, right?
That's probably what, yeah, I think it should say that. As long as that doesn't delay it at all, then I have no problem changing that.
Okay. Mr. Fine, did you want to address the legislation at all, or would you like to proceed with a motion?
Sure, I'll just briefly say something because I think everyone's pretty familiar with this law. I think this is a very important law. It's already the executive order that the county executive did is already making a difference and already helping restaurants. And it's important that we codify this, put it into law. It'll also provide a mechanism for enforcement. And I'm sure, as everyone knows, there is a sense of urgency on this legislation. And if anyone has any questions, happy to answer them.
Madam Chair.
Yes, Mr. Bergdorf.
Sam, I was generally I don't think we should be regulating business. In this instance, I couldn't agree with you more strongly, and I'm going to support this. I think this is a unique time, and we have to do everything that we can do to help businesses that are hanging on by their fingernails. So I'm going to support it. But I was thinking, your definitions, third-party delivery services, does that also include the supermarkets that do delivery services? Because I have no idea how they charge, whether it's Instacart or Whole Foods or Price Chopper. Are they swept up under this, or is this just for restaurant delivery services?
This is intended to apply to restaurant delivery services, and I don't believe it would apply. I assume you're referring to Instacart, but if Rebecca or if the attorneys or Patrick, if you have any comments on that.
Because everywhere it's sort of.
I think we define food service establishment under section 1C, meaning restaurant, drive-in, coffee shop, cafeteria. It doesn't seem takeout prepared food place. It seems to be the intent not to cover grocery stores.
Straight grocery stores are not intended, but it's mainly intended to cover the restaurants.
Okay, I mean, just a legitimate question, because I know people that will not go out of their house and are waiting for their Instacart or their Whole Foods or their Price Chopper, weekly delivery.
Should we add any clarification in subsection C about excluding grocery stores? I don't want to muddy this up.
So just, Madam Chair?
Yeah, no, okay, sure, Mr. Peter.
This is modeled after successful legislation in Westchester, New York City, which did not have any controversy. I believe because it's relatively clearly defined in the subsection that you mentioned. In addition, services like Price Chopper delivery, ShopRite delivery, Whole Foods and stuff is not third party, it's direct. And I believe Instacart is a service for the individual, not a third party doing it on behalf of the place. But even with that, it's not clearly defined, and that hasn't been an issue of confusion in any of the other localities that have passed this. And so the Restaurant Association and others who spoke the other night are strongly in favor of the version we've done as the least confusing, the most able to help, and it's consistent. And I think for us, consistency as much as possible is where we want to go. So that's my only point to that.
Okay, well, I feel comfortable if we have it on the record and we are comfortable with the verbiage that's here, that it's not going to impact home food. Got to be careful with my words. I almost said food delivery services. Supermarket or large food source delivery services.
Okay. Any other questions for Mr. Fine, or can we go to a motion?
I just have one question, and
Sure.
I'm not sure. I just throw it out to people. The section 2B, I have experience. I mean, listen, people are always trying to do goofy things with statutes. It shall be unlawful for a third-party food delivery service to charge a food service establishment any fee or fees other than a delivery fee for the use of their service greater than 5% of the purchase price for each online order. The first time I read it, what immediately occurred to me is, can you do cumulative? So I can say, all right, I'm charging you 5% for this, that's one fee, and then I'm going to charge you 5% for this, which is something else. And so I wondered if we needed to put cumulative in there. I guess the second sentence where it says, I don't know. I mean, I think it's probably all right, but I didn't know if we wanted to put in cumulative to just make it clear that, you know, somebody doesn't try and do something like that. I know that Matt.
It does say any.
It says fees.
It says
Any
fee
fee or
or
fees.
fees. Yeah, it's probably
I'd not
okay.
read it that way, but
So that's because in previous times they've tried to get around it by saying it's either combined fee or various fees. So that's why it said fee or fees.
Okay, so people have tried to do that.
Oh yeah.
Okay. All right, so the fee or fees deals with a cumulative issue. Okay, all right, well, if we feel comfortable with that, then fine.
Can I just ask for a clarification from Matt? Declared emergency. Are we assuming, does it take two people to declare an emergency, the governor and the county executive, or can either one of them declare an emergency?
It's either, Mr. Bergdorf. Sorry, Matt. It's
Nope,
in the
yeah,
definition.
I was going to refer to you anyway because that's one I didn't expect.
It's in the definition. It's either.
Okay.
yeah, we've covered it all.
Very good. I was going to call him Mr. Fine, but okay, Mr. Peter. I can't hear you.
Mr.
Sorry about
Peter.
If there's no other comments, I'd like to make a motion to move this, unless Mr. Fine.
Second,
Okay, motion by Mr. Peter, second by Ms. Cunningham. All in favor?
Aye.
Aye. Any opposed? Any opposed? No, okay. Motion passes unanimously. Thank you. Great work. Wow. Much appreciated. That brings us to the end of our agenda. May I have a motion to adjourn?
so moved.
Motion.
Thank you, Ms. Cunningham. Thank you, Mr. Ricard, for the second. All in favor?
Aye.
Aye.
Any opposed? Wants to keep talking? No. Okay. Thank you. Good night, everybody.